Turn these on.
Hey, Brian, this is Debbie. I can see everybody, but I can't hear anything yet.
Can you hear me, Debbie? Debbie, can you hear me?
Yes, now I can.
Okay.
Yes, I can now. Thank you.
Okay. Mr. Baxter, if we're ready, I'll go ahead and call the meeting to order. So it is 8:38, February 7th. I'd like to call this meeting of the Arkansas State Board of Pharmacy to order. We'll start with a quick roll call. I'll start on my far left, Mr. Harold Simpson, Dr. Beth Ann Davenport, Dr. Lynn Krause. Here. Dr. Rodney Richmond. Here. Dr. Lenora Newsom.
Here.
Dr. Clint Boone.
Here.
Dr. Debbie Mack.
Here.
I'd like to note that Dr. Mack is joining us via Zoom. And so with that, I'll turn it over to Mr. Baxter, our hearing officer, for our first case this morning. I would like to let Ms. Vales know that I'll be recusing from this particular case.
Good morning. It's good to see everyone. Happy Wednesday. My name is Joshua Baxter, and I'm the hearing officer today in the matter of Michael Frank Malone, case number 2022-129 before the Arkansas State Board of Pharmacy. Today is the 7th day of February. Please silence your cell phones and your devices now. I'm going to stick pretty much to the script for the first part, so I'm sure you've all heard this, but it bears repeating. For the benefit of anyone present today who may not have appeared in an administrative hearing, the board will base its decision solely on the evidence presented here today. This hearing is held under the Arkansas Administrative Procedures Act, which means that the strict rules of evidence do not apply, and the parties will be given latitude in introducing evidence. This is to promote a fair hearing and provide the board with adequate information to make a decision. To ensure efficiency of the proceeding, I will grant objections or caution the parties only as necessary. If there is anything that you have in your possession that you want the board to consider, you must offer it into evidence today. All participants to the hearing should be aware that these proceedings are subject to the Freedom of Information Act, FOIA, and as such, all parts of the hearing, including the deliberations of the board, are in the room. It is important that all persons necessary to the hearing are in the room during this hearing. If a party, attorney, or board member needs a break, feel free to advise me and we'll take that into consideration. Are there any questions at this point? In that case, we'll proceed with the identification. Would the respondent please identify yourself for the record?
Michael Frank Malone.
Good to see you. Mr. Malone, I see you are represented by counsel. Counsel, would you identify yourself for the record?
Attorney Dagan Clow.
Did you receive a copy of the order and notice of this hearing?
We have.
And board's counsel, would you please identify yourself for the record?
Ashley Vales, General Counsel for the Arkansas State Board of Pharmacy.
Fantastic. All right. For those of you who are or may be witnesses today in this matter, please raise your right hand to be sworn in. You swear or affirm that the testimony you're to give in this proceeding is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Sick. Counsels, are there any preliminary matters to be discussed at this time?
Yes, I have exhibits 1 through 9 that I moved to admit into evidence.
Are there any objections?
No objection.
All right, let the record reflect that exhibits 1 through 9 have been admitted to evidence.
Additionally, I would ask board members to take judicial notice of applicable Arkansas pharmacy laws and rules.
So noted. Any other preliminary matters?
None.
All right, counsel, you ready to proceed?
Yes.
Do either of you wish to make opening statements?
Yeah, I'm going to make a real brief opening statement. On or about October 28, 22, Dr. Malone was observed on video surveillance taking a non-controlled prescription drug from the pharmacy inventory at UAMS and placing it in his pocket without the knowledge and the consent of his employer and without payment for same. He has appeared before the board's informal review committee on January 10th, 2023. And then on January 11th, the board suspended his pharmacy license at an emergency hearing. Bringing this to a formal hearing has been delayed several times, but we are here to adjudicate that. Although I'll let Mr. Clow present his case, but that's basically all we have for the board today.
Respondent, you're welcome, or you can also defer.
We'll just make a short statement. Ladies and gentlemen of the board, appreciate y'all's time. Thank you for letting us be here. This is a situation where we exercise some poor decision-making skills. We should not have done what was done. We've learned from that. We have rectified. There was a criminal charge brought in this case that has been resolved at this point in time. The order for dismissal has been entered and the case will be dismissed on the 13th, so next week, without any findings of guilt, without any repercussions to Mr. Malone. He has reimbursed UAMS the 80 some odd dollars for the non-controlled substances which he took. He's been suspended for over a year at this time. We are just respectfully asking the board to consider reinstating him and allowing him to practice again. He understands the gravity of what he's done and is very sorry for it.
Thank you. Counsel, the board, are you ready to proceed? Call your first witness.
I'm going to decline to call a witness and just rest on the record.
Record so reflect. May proceed with your case and your first witness.
At this time, we would just ask the board to consider what's before them and make a decision based upon what you have.
Okay. So in this case, we'll just proceed to closing arguments. Any additional things which would like to be said?
Just briefly in closing, I think the board staff doesn't have any objection to Mr. or Dr. Malone receiving his license again. He's been suspended for a little over a year. And in light of that, we would defer to the board's judgment on that.
He is up to date on his continuing education. He is in compliance up with everything he's supposed to do at this point. So we were just asked the board to consider reinstating him at this time.
Board, I might have jumped the gun a little bit. Do you have any questions? Mr. Malone or counsel? Yes, sir.
Mr. Malone, are you sorry for what you did?
Yes, sir. I've been practicing as a pharmacist. It'll be 35 years, and this has been a very, I've learned, and it's been a very harrowing experience that basically I've had nightmares because of what has happened. And I can guarantee you, it was just bad decision making, and that will never happen again. Because I don't want to go through this, the emotional, physical, medical, everything. It's been terrible. And I sincerely apologize.
Thank you.
Sir.
Mr. Malone, we have several new board members here who are not familiar with the facts of your case. And I just want to make sure we get a couple of things straight for the record. First of all, the charges being dismissed were not a finding of innocence or that you didn't commit a crime or anything like that. It's because the prosecuting attorney failed to prosecute the case within the appropriate time period. Is that right?
If may I answer, I don't know if he fully understands. No, it's not. It had nothing to do with the time period. There was no statute of limitations issue or anything like that. The situation, in fact, we actually told the Times there would not be any time issues for the prosecution. It was after review of the facts, after speaking with Mr. Malone and myself, means the prosecutor, they decided that it was not a case that they would like to proceed with, that they thought it was not worth prosecuting. That was the decision that was made by the 6th Judicial District's prosecuting attorney's office.
What I'm not understanding is on your exhibit, it says the speedy trial told.
Yes, so speedy trial, they have 1 year to prosecute a case. And so what we agreed to is we would toll the time so that if they decided they wanted to come back and prosecute Mr. Malone, if he did anything in controversion of being a good citizen and a good steward, they could come back and prosecute that. We waived that time and said, we will not raise speedy trial as an issue. If you don't believe he's done what he's supposed to do, you can come back and prosecute him. And we are waiving the ability to challenge that in a timely manner.
Okay, thank you.
That's what that notation is.
One other question. Dr. Malone, I understand you're claiming that you did what you did because of just poor judgment or something like that. Is there any issue of addiction involved here?
No, it was not, no narcotics, no controlled substances at all. It was prednisone for my sinusitis and allergy and asthma, and Eliquis because I had suffered, I've had 2 pulmonary embolisms in the past.
Is there any issue of mental disease or defect?
No.
Could you just explain how it's poor judgment to go into the supply store at UAMS and reach into a bin and take drugs out?
It was just bad. I mean, all I can say was just bad judgment on my part. I just
Why
I didn't understand the policy and procedures fully, I guess, and that was that was all.
Why did you do it? That's what I don't understand.
I wasn't feeling good that day at all.
You what?
I wasn't feeling well that day at all.
And was this a drug you had a prescription
Yeah,
for?
I even have my prescriptions here with me. It's for for prednisone and Eliquis. Yeah, I had prescriptions for these medications.
Okay, so your idea was to take the drug that you didn't have with you from your prescription in order to, okay, thank you. That's all I have.
Yes. Did you seek out any counseling or talk to somebody about this type of behavior that you had?
I talked to my PCP about it.
But no additional counseling? Okay, what did you do during your suspension time?
Tried.
Okay.
And did work on my CEs to keep my CEs for the 2022-2023 year. Keep that abreast.
Thank you.
Are there any other questions from the board? Yes, ma'am.
Just to clarify, this was a singular incident, correct? Okay, that's all. Thank you.
Okay, seeing there are no further questions, to the extent that I did jump the gun, are there any additional closing statements which to be made?
No.
Right. At this time, we will go off the record for the board's recess for deliberations and a decision regarding the findings of fact, conclusions of law, and or any penalties to be handed down. Once the board reaches a decision, we will go back on the record.
So one question I had, Brian, so was he suspended from his license for an entire year? Is that what was said?
That is correct.
Brian, you're out, but I'm sorry. Okay, thank you.
Dr. Mack, he was suspended on an emergency hearing after appearing in front of the informal committee the day before. We have attempted with his attorney to get this case back on the board's docket for a formal hearing, and we've had delays. I think last time it was a situation at Dr. Malone's home where he couldn't be here. So it wasn't that the board chose to just suspend him that long. It's just been that long since we've been able to get him back on the docket.
Thank you very much.
Second that. There it goes.
It means hard. It should say
Push hard, not just touch, push. All right, let the record reflect. We're back on the record for voting from the board.
I'd like to make a motion, please. Matter of Dr. Malone, case number 2022-129, finding all allegations true. Charges proven. I move that we stand on the time served and pay his license and take it away.
we have a motion. Is there a second?
Second.
Have a second? Any further discussion before we take a vote? Right, recognizing Dr. Jolly is abstaining. All those in favor, say aye.
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 Any opposed?
Let the record reflect that the decision was unanimous. Please reduce the board decision to writing and make for attempt service on all the parties. If the respondent cares to appeal, obviously you're not going to. Appeal can be taken the Arkansas Administrative Procedures Act. There are no further questions or comments. This hearing is concluded and the record is closed.
Ladies and gentlemen of the board, thank you so much for your time.
Our next official appointment is at 10. If they show up a little bit early, we'll get started on that. You two guys are welcome to relax for a little bit. If the board will give me just a minute. I only have 3 copies of this, but I will pass it if you guys look at it. I can pull mine up on my computer. Just as an update from yesterday, I did go ahead and update that what we call the naloxone protocol. When we went back and looked, and I have sent message to the medical board and ADH folks, a lot of the requests to add some of those other products was actually through ADH and I believe even DHS. With that, when you go and look at a whole nother section of the statute, it actually is somewhat more permissive than the part in the Pharmacy Practice Act. So I've included that language in this protocol now to clarify. It's the part that has the 20-13. And then it says part A, any healthcare provider, or I can get this to pull up. Here we go. Under authority and eligibility, we previously had language in there, the standing orders issued pursuant to Arkansas Code this, but then I said additionally pursuant to Arkansas Code 2013-1804, because not only would it appear that pharmacists have the ability to prescribe and dispense to an individual patient, you also have the ability to give to other people. The thing is, with the protocol, renaming it more appropriately, the Arkansas Opioid Antagonist Protocol, because it's more than just naloxone now, with title was a big thing, and then outlining that. I basically said, I think we might have made some of this more difficult than it needed to be because of the other statute. But for a lot of pharmacists, they're going to still need the statewide protocol because it has the ability to name the physician at the bottom, at the very end, with ADH as the potential prescriber if it's a billing issue. That makes sense. Because not all insurances are recognizing yet that the pharmacist has the ability to be the prescriber of record. So this is what I put together and have sent over for medical review and hopeful adoption at their meeting later this week. They can get on the agenda.
So based on discussion yesterday, the aim was to just kind of normalize the phraseology to opioid antagonists.
Yes.
All right, now I may know the answer to this, but under authority and eligibility, the word naloxone still appears. Is that because that's the way it's written in that code?
In that part of statute, yes.
So do we,
So 1792-101 specifically says, I think I've still got this pulled up. Or if I don't, I can pull it up real quick. I can pull it up as fast as the computer will work.
well, I guess my point as you're pulling that up, while the rest of the document refers generically to the class of drugs, by specifically singling out naloxone under authority and eligibility, do we need to have some qualifying statement earlier under the introduction or purpose that says opioid antagonists such as naloxone mentioned above or others?
But not limited to.
Let me find that.
Because then again, under contraindications, which I'm assuming is not part of the code, it says do not administer with a known hypersensitivity to naloxone.
So here's the way that the Pharmacy Practice Act reads. Under a statewide protocol, a pharmacist may initiate therapy and administer or dispense or both drugs that include naloxone, specifically nicotine replacement therapy products and oral contraceptives. So in the protocol, now the way that I had put that, standard order is issued pursuant to Arkansas Code 1792-101-18, is where that is. Authorized licensed pharmacist order, dispense, or administer naloxone according to provisions of that code. Additionally, pursuant to Arkansas Code 2013-1804, and then it's adding overall opioid antagonist. But that's direct language in statute. So,
Well, it sounds like we'd have trouble getting around the statute. So, I mean, all the formulations that you mentioned yesterday are various and sundry formulations, including the one that's got 8 milligrams per mil, the topical nasal. They're still naloxone. Now, just recognize that by opening this up, we're also talking about naltrexone, which that's an opioid antagonist.
but it's not a fast acting.
Well,
So
does it say?
it's not available in a form that we've ever been asked to do it. If you go down to product availability, further on it, what I tried to do was address the antagonists such as naloxone and nalmefene that are FDA approved, commercially available. Right now, we don't have any requests for naltrexone, but it could be done because it's not I thought I had a statement for rapid.
Well, and this goes well beyond what we know that our scope is or our aim is, but there is an injectable naltrexone available veterinary wise.
If it's a Green Book drug, I believe it is, then it's only for veterinary use or can only be prescribed by veterinarians.
I'm just pointing out that there is one. As far as I know, otherwise it's just oral. I'm just making sure that we're correcting that in our correction that because the word naloxone appears in the code, just to make sure that the rest of what we've done matches up with that, including because if we're going to give something other than naloxone as an opioid antagonist or for future, if one to come on the market, then we're going to be concerned about the hypersensitivity to that drug as well.
Which is why we said, or any of the other components.
Well, that's referring to excipients and.
I meant whatever was in I could say any of the other components or. Yeah. Not administer an opioid agonist do not administer an opioid antagonist.
Does the naloxone.
Say with a known hypersensitivity.
Hey, can we take out the word naloxone there and just refer to the hypersensitivity of the opioid antagonist product? Do not administer opioid antagonist with known hypersensitivity to the product or any of its components.
How much better you die of opioid overdose or a rash?
To the medication or any,
I mean, just
any of
because you
the
have an
other
allergy
components.
to it doesn't mean you may not shouldn't get it. Looking for liability
Well,
because
if
they
it's-
had a rash.
well,
You
if
saved
it's
their
a
life.
type 1 hypersensitivity with anaphylaxis, then you don't want to give it.
Well, how do you know?
it's
It
only
says
if you do
none.
know. Like the person says, if they're wearing a band that says allergic to naloxone,
Oh, in our statute, it says we shouldn't give it. I don't know. You're right. I'm not gonna worry about it. The last thing down here where it says PCP name and contact information, I'm a little confused. What is that?
that was on there before because it was wanting you to try to see if they had a PCP to put it in your computer, basically.
For what?
That was in there on the one before, been there for years. Well, I think that just the second statement is the one that you actually want, is if you do not have a primary care provider, you should consult a physician of your choice.
And that's okay if,
Well, we can just delete the first line. It's literally, it's like, I saw that last night. I'm like, I don't know why that's in there. But
change
someone,
physician to provider. I would say if you do not have a primary care provider, you should consult a provider of your choice.
fixed.
Because we might be the provider in that situation.
Or a PA or a nurse practitioner.
Yeah.
Now, why is opioid antagonist protocol and all that treated differently than? It would be a dumb question, but really differently than, say, any of the other test and prescribed procedures.
I'm not sure I understand. I mean, so for opioid antagonists, there are two different areas of statute that give specific authority to pharmacists to be able to prescribe them, dispense them, administer them, or anything else.
But didn't we have a legislative ruling that allowed us to test and treat?
Yes, but we have specific protocols for those as well. So and they're on our website. We've got point of care test and treat for influenza and for streptococcus, strep throat, strep A. One thing that is interesting is at some point we're going to have to basically look at probably adopting the PrEP Act protocol for COVID, because once it disappears federally, the argument is we need a statewide protocol for it. And the board could literally make a motion to say, adopt the federal framework for COVID test and treat as a statewide protocol, and it'll take us a little bit to put it together in the state format and send it to medical board as well.
Would it be appropriate to do that today?
Do that now.
Okay, so do we want to put that in motion? Can someone
Oh, I
put that
thought
in
you were
motion?
making a motion.
Well, I don't think I can make a motion.
I'd like to make a motion that the Arkansas State Board of Pharmacy adopt the protocol of the PrEP Act for COVID treatment, prevention, diagnosis, whatever the PrEP Act involves.
John, any feedback on that motion? Does that sound,
I understand what you're saying.
okay? We have a second?
I'll second it.
All right. Motion to second. Any additional discussion?
Nope, not on that.
Okay. All those in favor of the motion, please signify by saying aye.
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 Any opposed? Okay, so we have, I believe five, one, two,
It still passed.
yeah, we have six yays and one abstention from Mr. Simpson. So motion passes.
Do you need a motion, John, for the this PC thing that we were talking about a few minutes ago?
Already fixed it. It's just what I was trying to do last night was get the main bulk of recognizing that the statewide protocol is being expanded for more than just naloxone. But I do have that in the Pharmacy Practice Act, it specifically says naloxone. In the other Public Health Act, it's any opioid antagonist. And given all the people it could be given to. So, but before it would say, you know, for any person at risk of experiencing opioid related drug overdose or anyone that might come in contact with them, the language in 2013-1804 is more expansive. Like it actually is a broader piece of language. So I used that part of the statute, which is specific in state law versus what we had made by proxy in the protocol.
Is the word naloxone broad enough to catch all of the antagonists that we want to be able to have used on an emergency basis under this protocol?
No, which is why we put additionally pursuant to Arkansas Code 2013-1804, healthcare professional acting in good faith may directly or by standing order prescribe, dispense, and supply an opioid antagonist, which is the catch-all word.
Could I suggest for clarity purposes that you might say may utilize, excuse me, may utilize naloxone under the law that authorizes that or other antagonist under the law that encompasses that.
And one of you guys let Harold see that printed form. Oh. Yeah. First page under authority and eligibility, and then under product availability. And I thought, let me see. And to Rodney's point on naltrexone, I thought I had put in because I intended to.
No, I'm saying administer naloxone under the provisions of 1792.
Then he's saying additionally, the next paragraph, additionally pursuant to 2013-1804.
Oh, okay.
Yeah,
Okay.
Because
I'm good.
1792 only uses the word
I'm
naloxone.
good.
In 2013.
I got it. I just didn't get down to the next paragraph. I'm fine.
And I could, I mean, if it would help, I could underline the additionally line or something.
Naloxone pursuant to.
Yep. Would you guys want me to put like in addition to naloxone and then comma pursuant to?
Sure.
And then I'll underline that. Just and
Well, be careful about underlining because if it adds emphasis, then you draw attention to it that maybe later in a context in which you don't understand, then that could take on significant meaning.
I put a colon at the end of it.
Bless you.
I can pull it up. I can figure out which buttons to push. Maybe. All right. Yeah. Okay. That's-
That making you sneeze.
Well, it's making me.
It'll let me in a second.
That time of year.
There you go. So in addition to naloxone pursuant to Arkansas Code 2013-1804. And I mean, the thing is with this protocol, if when I looked at it and even told the other folks I had on this message, I said, I've made it more complicated than it needed to be, because my fear is if we try to make the protocol too restrictive, people will just ignore it and use the other side of statute, and we're not going to even have the same type of records or suggestions or instructions. So I try to make it all encompassing where it would gather both sides of that. Because I do not personally know like how prevalent nalmefene is going to even be, but it could be. And we also know that there could be other,
Well, if it's on the product.
well, and we've got OTC Narcan now, which is a whole nother issue. So the OTC, when people ask me, well, how can I distribute this? Well, it's a different discussion, but I've even had a request to say, well, can the board waive the rule, which I've basically been told it's not appropriate to do, to allow prescription Narcan to be put in vending machines. But we have a rule from like 1980, you can't put prescription drugs or legend drugs in a coin-operated machine. But there's OTC Narcan, and if you get OTC Narcan, nobody cares what you do with it. And some people say, well, you don't care what we do with anything else. Like, well, a pharmacy could supply it to a harm reduction organization, and a harm reduction organization can distribute it however at that point. But there's still a state rule, you can't put prescription-only products in a coin-operated vending machine. Well, and the difficult part is if you say, and I've had to have some conversation of like, well, what's the difference between RX Narcan and OTC Narcan? And for all of us, well, no, in all honesty, it was money is the main thing. When it came out OTC, the price point was lower. It was well lower than what we could even get, law enforcement or any other type of pricing on it for like harm reduction organizations. The other thing is, for any of us that had Dr. Spadaro, OTC labeling is different for self-care. And if it is not everything approved by FDA in that self-care box, then it is not appropriate for OTC sale or provision without a healthcare professional. And we've done everything we can in Arkansas, like many other states, to go, this one is a big enough deal. Hardly anybody cares about it, but there are still some federal laws with that RX legend on it. So what we've tried to encourage a whole bunch of people to do is just say, guys, just get whatever you can that's OTC. Like OTC.
Can they not change the federal labeling?
No, they did, but it's just they haven't. There's two strains of product. I mean, remember when we had, the fun ones for us are things like Claritin. Claritin was prescription only when we got out of school, and it was $3.50 a tablet. And then when they came out with the OTC, it was $1 a tablet. And if you took a package of the OTC, it was a bubble card with child-resistant packaging and everything else. But if you popped a pill out, you could not tell the difference between the two. It's the same pill as it was. Prilosec was different because it was a tablet instead of a capsule, 20.6 milligrams, I think, instead of 20. But it was in that same type of packaging. So it was actually a different pill versus Claritin. My understanding, which is dangerous because I don't know all of that, but it is the same product, but the different labeling is the issue on the OTC. I haven't seen it. I've seen it for sale on websites and everything else, but it's coming quickly.
Forgive me for asking, but do you know if it has the same volume in it?
I believe same volume, same strength as the 4 milligram. And I try to be somewhat deliberate instead of naming all of the brand names of this stuff, that I put, naloxone in various forms, nasal spray solution, auto injector, nalmefene. Right now we see just nasal spray, but they're common examples, but it's not limited to. And I put include, but are not limited to. You want that qualifier?
Sure.
Because there could be another new ingredient in 6 months. And I think part of our thing is trying to future-proof this where we don't have to update this every
I think
time
you definitely need that.
there's a different strength or anything else. And there's, if you do not have a primary care provider, you should consult a provider of your choice. And Beth Ann was asking about, I think, operational. Or where put that? If you're using the protocol, you can either put, I mean, I would reduce it to writing, just like it was a call in or a verbal order. And that way you have your hard copy in your California file.
And it can either be the.
Yeah.
What did you say?
No, this is just a policy piece of protocol. On these for statewide protocols, they have to be approved by both the pharmacy board and the medical board. So it will be us basically getting it also to the medical board to see if they will also approve these changes. If not, the old one stands. And if not, you still have this secondary area of statute that is far more wide open than the Pharmacy Practice Act. Now that should be a period.
Yeah, and just, I guess, in context, this protocol, who's going to be reading this? Pharmacists?
This would be posted on our website if the medical board also endorses it.
Okay,
So
but who would read it? I mean, who's the target audience?
It's for pharmacists that want to use it.
Okay, so that last sentence should probably say, if the patient does not have a primary care provider, then they should contact a provider of their choice.
A lot of pharmacies do give this to the patient. So we're providing it for pharmacists, but what I have been told is a lot of pharmacists will keep this on file and basically say, this is how we've given this to you. I think some of them, I have heard, will put other resources on there. Like they'll have, you know, hey, get the Narcansaw app or go to, you know, oh, there's another website. There used to be Opie Rescue as an app, but I think it's gone now. So if you don't have it, yeah. This will be hard to see, but there's a Narcansaw app on your phone. You guys, if you haven't seen this, it's really neat because it's opioid overdose ? And it will literally walk you through how to identify and how to treat someone with an opioid overdose if you have some sort of opioid antagonist. The other thing is it has a button to help try to gather information where you can actually report the use of naloxone. So a lot of the programs, if someone is giving you free naloxone, they are basically requesting like where you got it and trying to get just demographic data, not necessarily that it was, you know, this specific person, but getting some demographic data just so we have better knowledge in Arkansas of the success of, you know, naloxone use, nalmefene use, Narcan use. I can reprint this if you guys have other editorial stuff.
Let me, and this is, I would never have thought of asking this question until 2 weeks ago. There's nothing in here, and I've not read it word for word, but there's nothing in here that gives a dose limit, right?
There's not really a dose limit. Right? And we've had that question where this has gotten more difficult under the old protocol, and I'm zooming around the page, is we would have people come to the pharmacy and go, well, I want to buy 15 kits because I have 15 officers, or I want to buy 10 kits and I want to have one in every go bag for our, you know, our fire station. And the original protocol was really for an individual person to get a dose or a few doses. And I said, well, under our old protocol, before this was all updated in 23, well, you'd have to put someone's name on it and dispense it. There's language in statute now that you can actually supply. Supply was added as this operational word right here. So it wasn't just dispense, it could also be supply, like supply on invoice to some state, municipal, or county entity, such as, you know, if it was the fire station, the police station, or whatever else, instead of it having to be a prescription. So it gave you choice to be able to invoice it. Most of those calls, we would say you need to get in touch with Arkansas Criminal Justice Institute, Arkansas Drug Director's Office. There's some programs within ADH itself where they would have either potentially free Narcan for first responders especially, or they could help them setting up contracts to get the reduced price for law enforcement or government entities.
Now they're being posted, there's a state law. You have to provide it in educational buildings. Just like an AED, it's gonna be mounted on the wall.
And that's where
Anyone has access to it at that point.
that's where, I mean, several of us said years ago, if we have AEDs in all these areas that are identified as an emergency resource, why don't we have them in the AED machines as well? Well, now there are some companies that are actually doing specialized stickers, labeling, and flags for advertisers to let people know that there is Narcan or naloxone products, opioid antagonists in those. There's the one for like high school and the one for college, and those are split up. And I would say it wrong, but one group was basically headed up by U of A CJI to help supply those. I think that was the high schools, like K through 12 stuff. And the other one was headed up by the state drug director. But we kept having pharmacists call us and go, I've got a school board member from this school and they're wondering how they get their Narcan. And we're going, well, there has been messaging sent out to all the schools, both colleges and, you know, K-12, of how there are free resources for this. If they'll engage, they need to do that. But a bunch of people got confused. Every time they hear there's a way to get Narcan, they go to the pharmacy and go, hey, I'm here for my free Narcan. And you're like, well, we don't have, you know, most pharmacies don't have free Narcan. We've got some HERO program grants that have gone through AORP, Arkansas Opioid Recovery Partnership. And I think we've had some through the state drug director that they do have that. We've got the hospital free Narcan programs.
Naloxone.
Yep.
through
Naloxone.
ACHI and SAMHSA, yeah. They're wanting us to expand.
Yeah. And they're, last I talked to them, I need to set up a meeting with one of their folks. She was telling me it, depending on when it was supplied, I think they're trying to transition to the OTC. Because when you've got the OTC labeling, you can do whatever you want with it. It is so much easier to deal with.
Not easy.
Well, it's so much easier than RX.
That's the hard.
Oh, I know.
If you know, like, say your emergency department's averaging 6 patients a week. Start putting that on discharge meds in the hospital, and that goes to 100 patients per week. To keep from having to enter every individual one, because that's really where the lift comes.
And I just mean it's easier because you don't have to treat it as a prescription only product if it's an OTC. In the distribution.
I mean, we make sure it's labeled like a, according to FDA, that if it was OTC, we wouldn't have to do that, right?
Yeah.
But I'd have to go look and see, like, we're just getting supply of product, and I don't know if it's just catch as catch can, and you just get what you get.
I know.
Could be OTC, could be non-OTC product. But there's a little card that comes with it too, that's got a QR code on it that links up to that app.
So that you can scan it.
You scan it, use it, goes right,
Yeah. Anyway, well, I'll print these for you guys to take a look at it. Unless you got any other feedback in the immediate. Otherwise, we can probably take a quick break, come back for our next hearing.
Sounds good. Well, I guess we'll break for what, 10 minutes?
Well, they're here.
There,
I don't know if they're ready,
Okay.
but we could say 10 minutes. And if they want to wait till 10, we'll call it back at 10. But if they're ready in 10 minutes, we start early.
okay.
Thank you, guys. Dr. Mack, are you still with us? She may have stepped away for just a minute, but
I'm here. I'm here.
all right. So-
Sorry, just getting off mute.
So, Mr. President, if it is okay with you, I believe that we can, in about 5 minutes, be done with this instead of having to have a hearing. That work? So, you guys want to introduce yourselves real quick, just for the record? And we'll have to,
Mike.
He's a pharmacist, in El Dorado at the hospital there. It was Medical Center in South Arkansas. The name has now been changed. He went through, the support group and, did that for 9 years. But now he is out of pharmacy, so to speak. He's working for the hospital, but in an administrative type position that doesn't require a pharmacy license. And so that's the basis of our compromise here today. Was
real briefly, because of Dr. Vinson's position with the hospital and him not having to have a pharmacist license, and in discussing with him, in many ways, it would help him to possibly go inactive on his pharmacist license. I mean, what I would say is, I know if I was in a facility like that and had a pharmacist license and was trying not to use it, I would constantly be drugged somewhere where they would use my license, even if that was on top of my normal duties. Their request earlier to us outside was, if he went inactive, would that end his contract? Could he end his indefinite contract with the board and his monitoring with the support group? And my answer was, well, yes, because if you go inactive in your license, you're not able to actually practice pharmacy at that point. It's not a disciplinary action. I think part of the caution was, if you just say, I surrender, it looks as if it's been a surrender for cause. And we're clarifying that this is not a surrender for cause. That is not that we have some disciplinary proceedings towards Dr. Benson at this time. But if he went inactive, he understands he will not be able to use his license. He can't counsel people, do clinical consults, but that's not part of his job now. If at some point in the future he wanted to come back, it would be coming back before the board to basically ask for reinstatement of active status. You saw one of those cases earlier today. His would likely be a little bit more different just because of his history and the contract he previously had at the support group, but it would be up to the board to decide whether or not to activate that license, under what conditions and whatever, back CE. I told him, my advice would be go ahead and just keep up with your CE. If nothing else, it's a good thing to learn, probably help you in your other hospital administrative functions. So unless the board had some complaint or problem with that, we think that a good settlement to this would be, he wants to go inactive, but was wanting to make sure that would not be disciplinary and would cut his indefinite contract with us and his monitoring with the support group.
Does this decision require board action?
It does not, unless there's something you guys go, no, that's not going to work. We just wanted to put it on the record for both us and Dr. Benson that this is the plan. We're all on the same page. We all understand what's going on.
Can I ask one question? I probably missed it right when y'all first started. No, why does he need to do this? Is it for the hospital job or something?
No, it's not that he needs to do this, but he is no longer in a pharmacy or pharmacist position. He's gone back to school, gotten some more education, is in a higher management position. My stance, and this is me saying it, not him, but for me, I know if I have a pharmacist license and I'm not in a pharmacist role, but there might be need for a pharmacist, I know that every time they think they need a little bit more pharmacists, I'm going to get pulled back. We've seen this, Dr. Mack, in corporate pharmacy where we've had people try to be on the store management side rather than the pharmacy management side. But because they're in that store, every time you get shorthanded in the pharmacy, they go, well, John can come back here and help us for 30 minutes, which is fine. That might help the pharmacy, but then I also am not able to do the 30 minutes of other work that I needed.
Basically, Eli's situation is, because he and I have interacted recently on some business related things. He's over more than just pharmacy. He's got probably respiratory care, he may have lab, et cetera. And it's just like in my role, I report to the CEO, but my CEO is not a pharmacist, but she has oversight of the pharmacy. It's the same thing with Eli, where he has oversight of the pharmacy from a report structure, but he's not practicing as a pharmacist.
But like for you, if you had a CFO that you're reporting to that also had a pharmacist license and a ice storm hits, and they go, we could use one more pharmacist down there. The CFO's already pulling their hair out, trying to keep up with their duties, but somebody would go, can you come down and help us for a little bit?
Yeah.
And it's a real tough spot to say no, and then people begrudge you versus being able to say, oh, I don't have an active license, so I can't do that.
Right.
So board staff, I mean, this is the plan we've all come up with, but in part, it's making sure nobody thinks that Eli was punished as part of this or that it's a disciplinary action.
He just wanted to do it in good faith instead of unilaterally saying he's through with his contract or he's surrendering or any of that. He just wanted to come in and have the board declare what the situation is, but this solution is a perfect solution to that situation.
And then if he ever decided he wanted to come back into practice, there's a pathway to do so.
Yep.
Back before the board.
Is that pathway very hard? I know if he does all his CE, I
We-
get it. Would
Yeah,
it be very hard for him?
We won't know till we get there if it ever happens. The hope for Eli is that never is an option. The direction he's going is probably a better direction than if he was trying to keep being a pharmacist right now. We've had a couple of other pharmacists that have had similar
It
roles.
depends on the day, I'm sure. No, there's probably some days you go, why did I do this?
You're exactly right.
We've had a couple that wound up in higher administration in places and went, you know what? I don't think I got my CE this year, so I'm going to go inactive. And then they realized
Right.
they can't drag me back anymore. Oh, but if that's okay with everyone, what we says we can help reflect it in letter and get that taken care of today for him.
Sounds good.
All right.
Thank you very
Thank you.
much.
Appreciate
Thanks for
everybody's
coming
time. Thank you.
Until one.
Dr. Curley, do we want to go ahead and nail down some June board? The June dates while we got a few?
I meant to look something up myself. Hold on just a minute. Because I think we figured out with Debbie and Lenora that we were covered on their stuff. If we did that second week, is that what you guys were looking at?
Yeah.
Yes. She is represented. So I don't know that she's not here. We can probably get our 1:30 moved up. Or 2:00 is, I think, going to be firm because we've not heard anything.
So I know that first week APA has their convention and you don't like to do it on the same week as them, is that correct?
No, we.
The second week's fine with me.
We oftentimes like to do it the same week as them because anything that is brand new information from the board, Tuesday, Wednesday, I can tell at APA when they have their conference on Friday is when I usually talk. But I think I'm looking at a couple of dates. I think that might be the same week as Utah School. I'm trying to find that.
Because I did remember we used to always had it, our meeting in a couple of days and then their meeting started and that kind of worked out, but.
And we have, I believe we probably have a couple of our members of the executive committee for support group that may actually try to attend Utah School this year. We do have the ability to potentially help sponsor that.
What's Utah School?
So Utah School, APHA Institute in Utah, and I'm trying to find their dates, it used to be called the Utah School on Alcoholism and Other Drug Dependencies. So when we were in school, I got to go after our first year of pharmacy school in June because I was working with the Student Outreach Services SOS program we had through Dr. Light. I have not been in several years. Dr. Newsom has been, Dr. McCready has been, Dr. Mack has been. NABP actually generally will have like 10 to 15 scholarships for people that are board members in places that are interested in going. It's generally right at the beginning of June, and I'm just having trouble finding these dates. But
What do you learn while you're there?
They will have expert speakers about addictive disease issues, treatment of addictive disease issues, but they also generally will have the times I went, some of the most meaningful things to me, not only were some of the speakers really outlining the disease of addiction, even though we had an addiction course at UMS at that time, but they would also have open meetings, like open AA or NA meetings, open Al-Anon meetings, so that you are fully immersed with people either in recovery or dealing with recovery. I can tell you that I got to go 3 times. I got to go once with UAMS and then twice with APHA as the national student leader. And every time that I went, you would have people in that room that had no idea what they had going on until they were in that room. And it's a highly emotional, heavy issue to go through. But you'll be in an Al-Anon meeting and someone will break down and go, oh my gosh, I did not realize this is my family. Or, oh my gosh, I didn't realize that I think I do have a problem. And there are resources there and people with lived experiences that can help you with that or help guide you to, look, you need to engage a counselor. Here's a group back home for you. I feel like the things that I learned in going there 3 times are things that I use on almost a daily basis sitting in the chair I do now, because we deal with a lot of addictive disease and mental health issues. Lenora, what would you share? Dr. Mack may have some as well.
Yeah.
So for me, it just really helped me understand more about the people that are coming in front of us, because I didn't ever really have a real good grasp on, the pharmacists and the issues that they were facing. So it was extremely eye-opening and very helpful.
Oh, Debbie can't hear you.
Yeah, I don't hear anybody else talking.
There you go.
Okay, you really don't know what's going on and how the pathophysiology behind it. You have people that have had issues, had problems, and they tell you how they got there and how they have worked things out. There's not only pharmacists, you also have physicians that help come in and talk to you.
It used to be a big group of dentists and physicians that would go. I know I think it's a little bit more pharmacy focused now, that it's mainly APHA, but it was a great experience.
Did you find out when the dates are for that?
I'm still searching.
In the institute.
All right, so this says May 29th to June 1st.
May 29th.
So that's perfect. I just finally found it.
Go.
Yeah.
Okay.
So we want to try to do the 4th and 5th instead of the 11th and 12th?
It's up to you guys. We can do either one. So the difference for me is if we did the 4th and 5th, if there was anything real pressing, but we don't have any, rule change that would be immediate or anything, or that are going into effect right then. So the 4th, 5th, or the 11th, 12th, either one will work pretty well for us, as best as we can tell.
I'll just speak up. It would be best for me if it was the 4th, 5th. So that's just.
Okay.
I'm fine with 4th, 5th.
It's good for me.
Yeah.
Debbie, how about you?
Yeah, either one works fine for me.
Okay.
Oh, what will it be?
I think I'm okay with either one.
Either one will work for me.
So Brian, if you go to Utah school, you'll just come right back and go to this meeting. Is that fine?
Yeah. That's fine with me.
I think,
Hopefully by the end of April.
yeah, at the June meeting is when we would anticipate having our first round of gold card, the prior authorization exemption list. I don't think that's going to take a huge amount of time for us to deal with because we'll have already had it go through committee.
Mm-hmm.
There's legislation for gold card that if a prescriber gets more than X percentage of their prior authorizations approved, they get a gold card, so they don't have to go through prior authorizations. But it also has the 3 pages that we, along with medical board, have to determine whether or not drugs are even eligible to have prior authorization criteria. So we're planning on gathering that. I did have this a separate update, but I have at least one company that called me and they would like to, instead of loading their drugs one at a time, be able to give us just an Excel spreadsheet that would be the same way that I would extrapolate the data, which I'm willing to work with them on that. I realized that we probably should have gone ahead and put therapeutic category. So I'm going to add that to our list, therapeutic category. And I think they believe they may have up to 400 drugs on it.
Is this prior auths in the traditional retail prescription, or does it carry over to prior auths required for infusions?
Drugs.
Just anything.
Medications, yeah, whether it's on medicals, well, it's only for plans that it applies to with the state, and that's not our determination. So there's a couple.
Medicare one.
That's
I thought
can't tell you.
federally funded programs were excluded. Maybe thinking of something else.
I'd have to pull it and look. I mean, I think they are, but I'd have to pull and look. Any fully insured plans would apply. It's up to the plan to determine, because so many of those things, they have parts that might fall under it, might not. We're just looking at, can this drug based on this criteria have a prior authorization? We'll get Brian to appoint a couple of folks to meet with our medical board colleagues and we'll go through the list. And I told him, I said, we're gonna have pharmacists, physicians, maybe a public member or two, and it's going to be a gigantic list. I said, and I think it's going to go about this fast. I mean, we'll be able to send you the information ahead of time. You go, yep, nope, question, yep, nope. I mean, I think it's going to be like that. Up to the,
A lot of roads if it's not.
it's up to the members if they want to, how much, I mean, most of it you have an understanding. This is the medication, here's the indication, or the therapeutic category, here's how much it costs, here's the reason why we'd like to have prior authorization.
Did we ever decide if REMS drugs were going to be excluded?
No, there's no exclusion on REMS drugs right now. We set that criteria where it was, if it's over $5,000, you can ask. If it's under 5,000, you have to have a whole nother, reason for, inappropriate use, potential injury. I can show you the way that
So when they feed the list to us, is it going to be the ones that they the insurance company may disagree with and say, no, we think this should still require a PA?
No, so what happens is they will send it to us. The Board of Pharmacy is basically the depository for all of the requests. We'll have the committee of the committee of the pharmacy and medical boards meet together to make basically a joint decision. And basically it will be a committee report to each of the boards to ask the boards to adopt it or to make changes.
Okay.
Anything that our boards do not grant or do not grant that exception so that they can have a PA, the appeal process is through the insurance commission, who will have a third party appointed to do a review of it. Like, we don't have to deal with the appeal. We do round one and then we're done.
Gotcha.
That's all we got.
John, does that really fall over? And I guess I'm thinking prior authorizations. I'm thinking about the impetus for looking at these prior authorizations, and it makes me wonder if that same impetus wouldn't apply to some of these plans that require you to use a more expensive brand name so they can get a generic. I mean, so they can get a rebate out of the deal instead of using a lesser cost generic.
I've got on the plan. We'll see how fast this works again.
Oh, I'm saying that.
No, I get what you're saying. And one of the things that I dealt with on this, takes a second for this pup to work again.
Did we decide 11th or 12th versus 4th or 5th?
Not yet.
Okay.
Yes.
I heard both. I never heard a motion for either.
Does anybody have an issue with the 11th and 12th? I can't remember.
That would not be the best for me.
Okay.
Rodney would have a conflict the 11th and 12th. Beth Ann would have a conflict the 4th and 5th. And I would say, I'm not saying skip a meeting, but if you're on any board, commission, or anything like that long enough, there's going to be a time you're going to have to miss a meeting. Here is the language actually for this, for the Act 575, and in just a second, I'll pull up the actual link. Here's the criteria that both medical board and pharmacy board adopted. Request for submission must meet the following criteria. It must cost equal to or greater than $5,000 per episode of care or on a monthly basis. Now, what I'm going to add to the questionnaire is, what is the cost of the drug? And I'll show you this in a second. But it's net. I want to know what the net cost is. So if you're trying to play, it costs $10,000, but we got $8,000 back, that's $2,000 cost to the plan. It's not $8,000 or $10,000, it's $2,000 because of exactly what you said. Here is the linked form. We have one entry in the form, which was me going, well, we've got nothing in here. Let me make sure it works. So I put a test med in it. So it's who the party is, their contact information, email, the medication brand name, if it's branded, generic name. Is this a branded or generic drug? This would also include, branded biologics that are branded or not, because some of them have multiple names. Is it a biosimilar or interchangeable biologic? Cost paid to pharmacy provider. I've been asked to update that to just say cost paid to medication provider, because some of this I realize will be medical, not pharmacy. These are the
cost or amount. And I know ticky tack, there's probably nothing you can do about it at this point. But
well,
sometimes cost and the amount paid is two different things.
And that's why the tweet to that I'm trying to refer to is, it's not just the cost paid, it's the cost to the plan, not necessarily what's paid to the pharmacy provider, because you might pay the pharmacy provider and then turn around and get a rebate on it that negates it. That makes sense?
No, it's just that I think that cost from an insurance standpoint as AWP.
No, that's not what we would say. I mean, it's what it actually costs, not what arbitrary number is. Reason to request to allow prior authorization criteria according to the guidance document. So they have to refer back to the guidance document itself to see why they are asking for it.
So you're saying they're gonna have to factor in their rebates, their back end rebates?
The request I've had is to go ahead and say it's not necessarily the amount that's paid to the individual. Because I mean, you could have times where there's no payment to the individual because it's free, even though the insurance cost would have some. It's what does it actually cost the insurance or the PBM, the net?
Yeah, that's a lot simpler than the cost to the pharmacy.
But and the funny thing is, I've had people say the easy thing is to say whatever's paid to the pharmacy or to the, clinic or the hospital or whatever, but that's not net. That's one thing. I mean, we have seen examples of it where, I mean, Medicaid is a good example. For years, we've known that there are brand name drugs preferred on Medicaid. And although more cost goes to the pharmacy in reimbursement, we know that it's an overall net cheaper drug for the plan because of the rebate structure.
Correct.
But that's just a discussion. You guys got to pick a date.
All right, so
Make a motion for it. What other person?
was it the 4th and 5th?
Yes.
Yes.
Okay. Okay, motion and a second. Any further discussion? Those in favor?
Aye.
Any opposed? June 4th and 5th it is.
Yes, you guys have? We got a long break. We'll try to see if we can get anybody moved up.
Yeah, that'd be great.
I bet we can get 130 moved up, but. Now we might be able to. Yeah, we'll make a phone call about our 3 o'clock to see if we can move it up or not. Because our 2 o'clock may take a little bit. We'll see. We already got food coming. Nope. All right, we'll break. If we get something moved up, we'll gather you guys back up. All right. Thank you.
What time are we breaking till?
Debbie, it may be 1 o'clock. If we can get anything moved up, I'll give you a call.
Okay, perfect. Thank you.
All right, thank you.
Bring us back some award-winning chili. Hey.